Okay, let's catch up with Karen Reed case. Karen Reed is requesting that the court dismiss 2 of the 3 charges brought by the Norfolk County DA against her for the death of her Boston PD boyfriend, John O'Keefe. In response, the Commonwealth has filed an opposition to the motion for dismissal, citing most importantly to a particular U.S. Supreme Court case that they say means the defense should lose. But does it? Watch until the end, and then I want to know what you think. And a little bit of a warning. We are about to get into the weeds of legal analysis here, but I'm going to try to make it as clear as possible for you. Let's get into it. So as you are undoubtedly aware, the Karen Reed murder case already went to trial, and the trial lasted 9 weeks and 84 years.
It's been 84 years.
And ended up with the most anticlimactic result when the jury ultimately concluded that they couldn't come to a conclusion. After multiple attempts to encourage the jury to keep working at deliberations, ultimately Judge Beverly Cannone decided that the jury was hung and ordered a mistrial. Immediately, the Norfolk County DA's office announced that they absolutely planned to retry Karen Reed. And so everyone that was following this case, undoubtedly exhausted, at least if you're like me anyway, was mentally preparing for another trial to happen within the year. But since then, a number of jurors actually chose to reach out to the defense team saying, well, actually, we did conclude on 2 of the 3 charges. And it was just 1 charge that we couldn't agree on. But as to those other 2 charges, they said that they unanimously voted to acquit. So the defense team came out very quickly with a motion to dismiss those 2 charges, and then the Commonwealth responded in opposition, and the defense filed a reply to that opposition. And so here we are. Judge Cannone will be deciding this issue very, very soon, and obviously there are a lot of people interested in what she's going to be saying. So the question is, what are the odds that the defense actually gets what they want here? So let's first look at the main arguments in the defense's motion to dismiss for this. But before we do that, I have to thank this video sponsor. This video is sponsored by AccuFlow. AccuFlow is a time-blocking app designed to simplify your management of calendars, tasks, and plans. One of the things that it can do is pull from all the different apps that you use to bring everything into one place, so you don't have to switch between tabs and windows just to get things done. And otherwise, it also allows you to create and modify your own schedule as you move throughout your day. They have this brilliant way of thinking about it right here on their website, where they ask, how many hours are you losing each week to productivity killers such as interruptions, juggling between apps, and manual scheduling? That, for me personally, hits very close to home, because there have been so many times when I've intended to get a million things done, so many videos that I wanted to make, so many topics that I wanted to discuss. And getting derailed by distractions, interruptions, and a lack of focus is always the most disheartening thing. And because of that, I am always looking for a better way to organize and manage my time and minimize those distractions, because my brain is always going in multiple directions at once. And that's the great thing about AccuFlow. Already with my first uses of this app, I'm seeing how I can visually create these time blocks for tasks that are really necessary for my success. And seeing them out in a calendar format like that is helpful to see what's realistic for me to get done in a day and maybe what's not so realistic. I can compare how much time I thought a task would take me at the beginning of the day to how much time I actually took with that task, and really analyze what's going on with my day to either help me succeed with my goals or to get in the way of those goals. And since my life is about to get even more complicated with a baby on the way, this has been a huge concern of mine for the last, 8 months. So if organizing, time management, and productivity are something that you need to improve, check out AccuFlow with their 7-day free trial and see how it works for you. Link is in the description below. Otherwise, thanks again to AccuFlow for sponsoring this video. Okay, let's get back to the video. The defense basically makes 2 main arguments. The first is that they say that after the trial concluded, not long afterwards, they started hearing from jurors and intermediaries who said that they had spoken with other jurors, all of whom say the same thing. They say that the jury was unanimous in acquitting Karen Reed on the first charge and the 3rd charge. And now, as a reminder, she was charged with 3 crimes here. The first was second-degree murder. The second was manslaughter while operating a motor vehicle under the influence. And the 3rd was essentially leaving the scene after committing a crime. And as a further reminder, the 2nd charge, so the DUI manslaughter type charge, had 2 lesser included offenses. Those were involuntary manslaughter and and motor vehicle homicide, which is essentially where someone was driving under the influence and was being negligent. So in the defense's motion, the defense is arguing that jurors have come forward to say that although they couldn't agree on where they landed as to the second charge, the manslaughter DUI charge, they did, in fact, all agree at the end that Karen Reed was not guilty of the first charge, second-degree murder, or the third charge, leaving the scene after the crime. Now, at the time that the defense filed their motion, it was actually just 3 jurors that they either heard from directly or heard from through some kind of an intermediary who says that they spoke with a jury who said exactly this. But now it looks like that number has reportedly gone up to 5 jurors. So the defense is arguing that because the jury actually did come to a conclusion on 2 of the 3 charges, and that the jury voted unanimously to acquit Karen Reed on those charges, that these 2 should actually be dismissed. The reason for this is because of the rule against double jeopardy. Now, you've probably heard something about double jeopardy before. It basically means that where the government has tried a person for a particular crime and the defendant has been acquitted, the government can't either appeal that acquittal to try to turn it into a conviction, nor can they just try the person again. Once there's an acquittal at the trial court level, that's it. The defendant is free to go and they are not going to be charged again for that same offense. Now, there are some situations where someone has been tried before and the government comes back and tries them again, and it's considered legal to do so. One is where there has been a mistrial declared for one reason or another, most commonly because the jury in the initial trial can't come to a unanimous conclusion. The reason there for why the government can come back with a second trial is because there was no ultimate resolution to the charges. Now, another situation where the government can try the defendant again for the same fact pattern is where they charge for a slightly different crime. For example, Derek Chauvin was tried under both Minnesota state law and then under federal law for the 2020 death of George Floyd. But anyway, the point is where the jury has actually reached a conclusion as to a particular verdict, and particularly where they've come to acquit the defendant on a particular charge, double jeopardy prevents retrial on that particular charge. And so here the defense is saying, well, hey, we just found out from a handful of jurors who reached out to us unsolicited, and they said that they in fact did reach a verdict on those 2 charges, so we need to dismiss those 2 from retrial. So that's their first argument. The second argument is that there wasn't a quote-unquote manifest necessity to declare a mistrial on the counts on which the jury unanimously agreed. Basically, what they're saying here is that the defendant did not actually consent to the mistrial declaration here, and that therefore, in order for the mistrial to be proper, there needed to be a manifest necessity to declare it a mistrial. And here they cite 2 Massachusetts Supreme Court case law that says that before a court declares a mistrial for manifest necessity, first, counsel must have been given full opportunity to be heard, and second, the trial judge must have given careful consideration to alternatives to a mistrial. And so they basically say that when the jury came back that final time, saying that they were still at an impasse, Judge Cannone didn't give the defense an opportunity to be heard on whether this should be declared a mistrial or not. Now, I will say, of these 2 arguments by the defense here, the first one is much stronger than the second one. And this is fairly common with any kind of legal filing. Generally speaking, you want to start with your strongest argument, and whatever weaker arguments you have might follow. But the reason why I personally think that the second argument is actually fairly weak is because Judge Cannone was bound by Massachusetts law regarding the Tui Rodriguez instruction. Remember, the jury came back a couple times before this and said that they were stuck. And so Judge Cannone did hear from both sides during those previous times when they came back stuck and asked them what they would prefer in terms of how they would like to proceed, in terms of how they would like to move forward with that. And so ultimately, after that back and forth between the defense and the Commonwealth, Judge Cannone ended up sending them back a couple times before giving them what's called the Tui Rodriguez instructions. Now, those instructions are the Massachusetts equivalent to what is known in federal law as the Allen instructions. Basically, these instructions tell the jury, if you don't decide this case, that means the jury is hung and the judge will declare a mistrial. It's considered a last resort instruction because once it's given, and if the jury after that comes back without a verdict, then the judge basically has to declare a mistrial at that point. So here's where Judge Cannone read the Tui Rodriguez instructions to the jury after a couple encouragements to go back and try again.
All right. So, jurors, I am in receipt of your note. Judge Cannone, despite our commitment to the duty entrusted to us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind. The divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable. We recognize the weight of this admission and the implications it holds. So, Mr. Foreman and members of the jury, I have an instruction for you. Our Constitution and laws provide that in a criminal case, the principal method for deciding questions of fact is the verdict of a jury. In most cases, and perhaps strictly speaking in all cases, absolute certainty cannot be attained, nor is it expected. The verdict to which each juror agrees must, of course, be his or her own verdict, the result of his or her own convictions, and not merely an acquiescence in the conclusions of the other jurors. Still, in order to bring 12 minds to a unanimous result, you must examine the issues you have to decide with candor and with a proper regard and respect for each other's opinions. You should consider that it is desirable that this case be decided. You have been selected in the same manner and from the same source as any future jury would be selected. There is no reason to suppose that this case will ever be submitted to 12 persons who are more intelligent, more impartial, or more competent to decide it than you are, or that more or clearer evidence will be produced at another trial. With all this in mind, it is your duty to decide this case if you can do so conscientiously. In order to make a decision more attainable, the law always imposes the burden of proof on the Commonwealth to establish every essential element of each indictment beyond a reasonable doubt. If you are left with a reasonable doubt as to any essential element of any indictment, then the defendant is entitled to the benefit of that doubt and must be found not guilty on that indictment. In conferring together, you ought to give proper respect to each other's opinions and listen with an open mind to each other's arguments. Where there is disagreement, those jurors who would find the defendant not guilty should consider whether the doubt in their own minds is a reasonable one, if it makes no impression upon the minds of the other jurors, who are equally honest and equally intelligent, who have heard the same evidence with the same attention, who have an equal desire to arrive at the truth, and who have taken the same oath as jurors. At the same time, those jurors who would find the defendant guilty ought seriously to ask themselves whether they may not reasonably doubt the correctness of their judgment if it is not shared by other members of the jury. They should ask themselves whether they should distrust the weight or sufficiency of the evidence if it has failed to convince the minds of their fellow jurors beyond a reasonable doubt. I will now ask you, Mr. Foreman, and members of the jury to return to your deliberations with these instructions in mind. And as with my final instructions and the supplemental instructions I sent in, I will send in a copy of this charge as well. All right, so may that be marked, Madam Court Reporter, please. All right, so thank you. We'll send you folks back out to deliberate.
All rise for the court, please. Jurors, follow me.
And if you remember from the verdict watch, the defense actually wanted to go pretty much straight to this instruction the first time that the jury sent back a note saying that they were stuck. On the other hand, it was the Commonwealth actually that argued for sending them back multiple times before ultimately resorting to the Tuohy-Rodriguez instruction. So I will say that now for the defense to say that they didn't consent to a mistrial is a little bit of a climb for them to make. And all of that together means that I think that this second argument that they made really isn't much of a winning argument. Don't get me wrong, I love this defense team. I just think that this particular argument isn't the best. However, the first argument, in my opinion, is a much stronger one. So let me clarify here what I mean. To me, there probably isn't enough for Judge Cannone to outright dismiss Charge 1 and Charge 3 just on these papers, on the arguments that are in these filings going back and forth between the two sides. However, I do think that there is certainly enough here for Judge Cannone to set a hearing where she brings back all of the jurors and asks them if they did in fact choose to acquit Karen Read on Charge 1 and on Charge 3 at the end of their deliberations. To me, there is enough here to warrant that kind of investigation, partly because of the fact that this is such a high-profile case and one that has resulted in so much tension in the community going back and forth between both sides. And I think that the case law cited by the Commonwealth in opposition to the motion to dismiss it just doesn't do enough to defeat it. So let's talk about what the Commonwealth argued in their opposition. The Commonwealth makes a couple different arguments, but their strongest one cites to a United States Supreme Court case called Bluford v. Arkansas. Basically, the point that the Commonwealth is trying to make with this case is that they say that because the jury failed to come back with an official conclusion about these charges, too bad, so sad, there's no double jeopardy on charge 1 and charge 3, so they shouldn't be dismissed. So the first question is, what does Bluford v. Arkansas even say? What happened in that case? So in Bluford v. Arkansas, the defendant was charged with a single charge of capital murder. This charge also included 3 lesser included offenses: first-degree murder, manslaughter, and negligent homicide. Now, the jury came back after everything and said that they were unable to come to a final conclusion on the charge. And the foreperson there even told the court, hey, we actually are unanimous on acquitting on capital murder and first-degree murder, but we're stuck on these lower, lesser included offenses. And then the judge sent them back to deliberate one last time, and they came back and said, nope, we're still hung on this charge. Now, there are 2 important points to take away from this case. Number 1 is that the U.S. Supreme Court said that these were not separate charges, but all part of a single charge. And I will note that when the Commonwealth cited to this case in their opposition, they actually misstated this, and I think that it's an important point. On page 6 of their opposition, the Commonwealth said, in Bluford, the jury sent a note to the court indicating that they were hopelessly deadlocked, and the court asked the foreperson to disclose the jury's votes on the 3 charges: first-degree murder, manslaughter, and negligent homicide. But this is actually wrong because the Massachusetts Supreme Court has stated that a lesser included offense is part of a single charge, not a separate charge or separate offense. A trial court on a single complaint or indictment is not a trial on 2 or more offenses, and the identification of applicable lesser included offenses at the time the case is submitted to the jury does not transform the trial into a trial on 2 or more offenses. Now, the reason why I think that this is important is because Bluford was about a single charge and 3 lesser included offenses. The defendant was trying to say that because the jury was deadlocked on the lower of the lesser included offenses, that this meant that they actually had acquitted on those higher offenses, capital murder and first-degree murder. But the Supreme Court said, well, no, we can't necessarily say that because when the jury went back that final time to deliberate, we don't actually know where they really landed on these various levels of offenses within the same charge. And they said, actually, in reality, in these deliberations, the jury is going to go back and forth while they discuss, and it's not uncommon for a jury to revisit an offense that they previously had made a conclusion on. To take a direct quote from the court's opinion, here's what the court actually said. It was therefore possible for Bluford's jury to revisit the offenses of capital and first-degree murder, notwithstanding its earlier votes. And because of that possibility, the foreperson's report prior to the end of deliberations lacked the finality necessary to amount to an acquittal on those offenses, quite apart from any requirement that a formal verdict be returned or judgment entered. So in other words, because they had the possibility of revisiting these higher level offenses in that final deliberation, the Supreme Court said, we can't actually be sure that they really ended up deciding on an acquittal for capital murder and first-degree murder. Now, in order for Bluford v. Arkansas to be a perfect 1-to-1 match to the Karen Reed motion to dismiss, it would need to be the case that the defense hearing the Karen Reed case is arguing that the higher level offenses within the second charge need to be dismissed because the jury got stuck on the lesser included offenses within the second charge. But here, take note, the defense isn't even arguing about the second charge at all here. We are not talking about lesser included offenses. So Bluford v. Arkansas is not a perfect 1-to-1 match because we're not talking about any of these lesser included offenses. We are talking about entirely separate charges that the jurors are saying that they actually made unanimous conclusions about. So if you're the defense and you are arguing about why Bluford is not a 1-to-1 match to the current situation, the word that you would be using is distinguishable. And in my opinion, my own personal analysis on this, I could be wrong, but this is just the way that I see this. The current case, the Karen Reed case, is in fact distinguishable from Bluford v. Arkansas. And there are 2 main reasons. First, like I said, we're talking about separate charges in the Karen Reed case where jurors are coming back one by one to say, we actually came to a final conclusion about these at the very end of our deliberations, and these conclusions were unanimous. And second, it's because these jurors are coming out of the woodwork are in fact saying those conclusions were final. This is different from Bluford because remember, in that case, the U.S. Supreme Court said that the last report that anybody had about the unanimity from the foreperson was before the last time that the jury went back in for deliberations. So, of course, when they did go back for deliberations, they could have changed their mind even about their unanimity on those parts too. And so the court said the jurors were never told that once they had reasonable doubt, they could not rethink the issue. The jury was free to reconsider a greater offense, even after considering a lesser one. And as I've highlighted, we have jurors coming forward in this case, the Karen Reed case, and saying that that was not what happened here. Now, I will admit, this is not a slam dunk for the defense. Judge Cannone could totally say that, yes, there are differences between this case and Bluford, but, those differences really aren't enough to discard the reasoning in the Bluford case. In other words, she could say, hey, just like the jurors were free to revisit and reconsider a greater offense within the same charge in Bluford, here they were also free to revisit the separate charges in that final deliberation too. And more than that, I should note that the communication by the jury in that final note to the court about the impasse didn't really give any indication that they had made conclusions about separate charges. Rather, it basically said, we're stuck, and we don't think that we can get unstuck. Specifically, this is what the jury said.
All right, Mr. Foreman, I am in receipt of your note. Judge Cannone, despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. I'm not going to do that to you folks. Your service is complete. I'm declaring a mistrial in this case. I'll be in to see you privately in a few minutes. So thank you so much for your service. Okay.
All rise for the court, please.
Now, note that the foreman here said that some of the members of the jury firmly believed that the evidence surpassed the burden of proof establishing the elements of the charges beyond reasonable doubt, and that other members of the jury felt that it did not meet the burden of proof. We have to admit the plain meaning of that language, the understanding that basically all of us had in real time watching this, was that they were stuck on all of the charges, including charge 1 and charge 3. There was nothing in that particular statement that seemed to suggest that there was a difference between how they were viewing charge 1, charge 2, and charge 3. However, given the fact that even the Commonwealth made a mistake in distinguishing between the definition of separate charges and lesser included offenses within a particular charge when they were talking about the Bluford case, it is possible that what the jury meant when they said charges was really lesser included offenses within one of the charges. But that is a hard argument to make, I have to admit. And so on this point, the Commonwealth is pointing to case law that says essentially, in order for it to be a valid verdict, it has to be a public verdict given in open court as a unanimous act of the jury and affirmed and entered into the record. For example, on this point, they cite to a Massachusetts Supreme Court case called a Juvenile v. Commonwealth. In that case, there was a juvenile on trial for murder. After 4 days of deliberations, the jury informed the judge in open court that they were deadlocked. And because of that, a mistrial was declared. Now, after that happened and everything ended, verdict slips were found in the deliberation room showing entries of not guilty as to murder in the first degree and murder in the second degree. And these verdict slips had actually been signed by the foreman too. However, the Massachusetts Supreme Court found that these verdict slips did not entitle the defendant findings of not guilty for first degree or second degree murder. The court likewise found that it did not entitle the defendant to a dismissal of the murder complaint entirely, nor did it entitle him to subpoena the jury's foreman to impeach the jury's report that they had been deadlocked. So looking at this case and applying it to the Karen Reed case, the court might say, hey, we're actually under no obligation to do any further investigation into this question because at the end of the day, just like was the case in a Juvenile v. Commonwealth, this particular jury in the Karen Reed case also said flat out that they couldn't come to a conclusion. However, I should point out that here, just like in Bluford v. Arkansas, this Massachusetts Supreme Court case A Juvenile v. Commonwealth was also about a single charge with lesser included offenses. And a big part of the Massachusetts Supreme Court's reasoning was this part right here, where they said it must be recognized as a practical matter that jury votes on included offenses may be the result of temporary compromise in an effort to reach unanimity. A jury should not be precluded from reconsidering a previous vote on any issue, and the weight of final adjudication should not be given to any jury action that is not returned in a final verdict. So once again, the Commonwealth is pointing to a case here that is distinguishable from the current case, because the Karen Reed case is one where we're not even talking about dismissing the bigger offenses attached to other lesser included offenses. We are talking about dismissing legitimately separate charges. And the one that has lesser included offenses isn't even part of the argument to begin with. So basically, what I think is that this is going to come down to whether or not Judge Cannone is convinced that there's enough ambiguity in the air between the last communication that the jury gave after the Tui Rodriguez instruction and these new revelations from the jurors coming forward. If she agrees that there is some ambiguity there, maybe she will allow for a separate hearing to bring the jury back and hear them on this question. At the very end, when they walked out of deliberation that last time, were they actually unanimous in acquitting on charge 1 and charge 3? This would require a hearing from each juror on the stand. And it would require every single juror to say, yes, we decided to acquit on charge 1 and on charge 3, and the only ones we were split on were charge 2. If the defense can get that hearing and the jurors all end up saying the same thing without a single juror saying otherwise, I think Karen Reed can and should get charge 1 and charge 3 dismissed. But those are my thoughts. What do you think? I do know this really required us to get into the weeds of legal analysis, so I hope everything was clear enough for everyone to fully understand where these issues might turn. And if so, do you think that charge 1 and charge 3 should be dismissed here? Or do you think that the Commonwealth should be able to proceed on all 3 charges? Let us know in the comments down below. Otherwise, I hope you enjoyed this, or at least found it interesting or informative. And if you did, I would love it if you could hit the like button. It does help us with the YouTube algorithm gods. And if you're new here and you want to see more coverage of crazy cases and interesting legal topics, be sure to hit the subscribe button and the notification bell so you can find out when the next video is out. And if you're really loving the content and you want to know how to best support the channel and in the process get perks like early access to videos like this one, consider becoming a member of Bite Club. You can join either through YouTube memberships or by supporting on Patreon. Links to both are in the description below. Otherwise, see you in the next one.